Hello, I'm Elizabeth Gibson, Senior Staff Attorney at the New York Legal Assistance Group, and I'll be your moderator tonight. Thank you for joining the New York City Bar Association for tonight's conversation, 100 Days Accountability on Immigration. Wanted to say a quick thank you to the association's Immigration and Nationality Law Committee and Rule of Law Task Force for sponsoring the event. Both have some great reports on many of the topics that we will be discussing tonight. And I would also recommend checking back in a week or two for two new documents, including hopefully a letter to the Attorney General on some immigration matters, as well as a letter addressing barriers at US citizenship and immigration services. We also have some materials from our panelists, which you should be able to find in the question and answer feature in Zoom, and will hopefully be circulated to everyone separately as well. Just as an initial note, the chat feature is turned off, but if you have questions while any of the panelists are speaking, you can go ahead and use the question and answer program for that. And we will be keeping an eye on those, but saving questions for the last 15 or minutes or so of our program tonight. Today, we have an absolutely fantastic panel that is going to cover the full spectrum of immigration law. We have Denise Bell from Amnesty International, who is going to be talking about family separation and children. Aaron Reichlin-Melnick from the American Immigration Council, who will be talking a bit about enforcement and due process. Kennji Kizuka from Human Rights First, who will be talking about humanitarian protections. Charles Wheeler from Catholic Legal Immigration Network or Clinic, who'll be talking about family-based applications, and Claire Razzolini from Gibney, Anthony, and Flaherty, who'll be talking about the business immigration law side of things. That is an incredible lineup. So I'm just going to very briefly set the scene, but then get right to our panelists, because that is what we are here for. As of April 30th, 2021, so last week, President Joe Biden's been in office for 100 days. We're here the week after that because we wanted to give our panelists a moment to fully reflect on what's happened in those first 100 days, and also because a few of the immigration executive actions that happened early in the administration got started a few days after the administration came in. Under the Trump administration, immigration law saw some dramatic changes, primarily through agency regulation and policy rather than legislation. And it's of note, those changes were not necessarily focused on one particular subset of immigrants, although I think it's fair to say that many of the policies disproportionately affected certain groups. However, we saw sweeping changes curtailing humanitarian programs, the functioning of the immigration courts, family reunification, business immigration, and longstanding legal pathways to status. Now we have had a few months to see how the new administration is doing on its campaign promises. And just to start us off with an example of how uncertain all of this can be, restoring refugee resettlement in the United States, I think, was expected by many to be low-hanging fruit as far as immigration issues in the new administration. However, last month, we saw the administration announce it would leave the refugee cap at 15,000 people, the historically low number set by the Trump administration. Following quite the uproar in response, the administration backtracked, and this week, Biden raised the cap to 62,500 refugees. But it certainly has been, I think, for many, a wake-up call that something considered by many to be as less contentious as refugee resettlement ended up being that difficult. And so it'll be interesting to see what happens in some of the more controversial or obscure areas of immigration law. We obviously won't have final answers on many of the issues we talk about tonight, but our panelists will be discussing what has changed, what has not changed, and where do we go from here. So we're going to start off with Denise, with what has arguably been leading immigration headlines recently, or for really several of the past years, and that is family separation and children. Denise, I'm sure many of our attendees have been following this issue in the news, but can you start off by just briefly summing up what the situation was heading into the current administration?
Thank you, Elizabeth. And I'd like to say hello to everyone. And it's such a pleasure to be here. And thank you to Elizabeth for organizing us and keeping us on track. So I'm confident many people are aware, but I'll set up the scene. Under the previous administration, under the Trump presidency, there was a policy of forcible family separation. And the reason I use forcible is because family separation has always occurred at the border in the context of when adults arrive with children and the adult is not a parent or a legal guardian. The Department of Homeland Security, specifically Custom and Border Protection, can separate them under law. We don't like that. We want that law changed, but that's what it is. But under the Trump administration, there was a deliberate policy to target all families arriving at the border and forcibly separate them. Most visibly, many of us will have read about this beginning in the spring of 2018, beginning with the announcement of something called the zero tolerance policy, which laid the framework for this, which was the prosecution of adults arriving without visas or other authorization to enter the United States. Those adults would be arrested, separated from the children, sent to detention or a criminal facility, and the children would be put into the care and custody of the government as unaccompanied children. This was a horrendous policy. It actually was predated by a soft pilot in 2017. And what is really the horror of this and the shame is that government officials at the time knew this was happening, knew that it would lead to horrible results, but they thought no conscionable person would pursue this. And so they listed the failures of the policy and set it aside, not understanding that it truly was a trial balloon for what we saw in 2018. Thanks to the ACLU and a body of advocates, there was a lawsuit and a federal judge intervened and shut down this policy, calling it unconscionable, that this shocked the conscience, which it did at the minimum. And that is called the Miss L litigation. There were several other litigation, pieces of litigation, but that's mainly the primary body. All told, around 5,500 children were separated from their parents. Right now, what we know is that around 1,000 still have to be reunited. And around 400, nearly 500 children, we can't identify where their parents or guardians are. It's shocking. As the Secretary of the Department of Homeland Security has said, and the Executive Director of the Interagency Task Force, which I'll get to in a second, has said, this Interagency Task Force on reunifying families, that the Trump administration, amongst the many horrible things it did around the family separation policy, it kept shoddy records and seemingly deliberately. So families could not be tracked. I remember being in meetings with administration officials at the time in the precursor leading up to this, and they assured us that they were tracking children who were separated from their families under color of law, because they weren't with a guardian or a parent, but they weren't even doing it then. So right now we have around 450 children who don't know where their parents are. Also, where we stood is the President Biden as a candidate had promised, this is one of his top promises, was to set up a task force with the objective of reunifying these families, and also to look into accountability for it. One of the first things that he has done as president is through an executive order to establish an interagency task force to reunify those families. So that's where we are right now. The last thing I'll leave is that the Department of Justice, the Office of Inspector General in the fall had published a draft report. And then in January, before President Biden assumed office, published the final report. And in it lays out very clearly that the government, and in particular, the Department of Justice, under the then Attorney General Sessions and his Deputy General Rosenstein, deliberately set out a policy of cruelty to separate these families, knowing that the consequences, what the consequences would be, and did not put in the apparatus to prevent families losing track of their children, did not put in any processes to protect the best interests of the welfare of the children. This was an intergovernmental failure. Amnesty International has found that this amounts to torture. We published a report on this in 2018, saying that this policy amounted to acts of torture. Physicians for Human Rights has also done this. And then this report from the government lays out the actual rationale that we can argue under international human rights standards. This amounts to torture. And we will be pursuing accountability as well as redress for the families. And that's where we're looking to move.
And so thank you very much for reminding us of the gravity of this horrific situation, Denise. In terms of the first 100 days of this administration, you mentioned the creation of the task force. Where are we seeing progress, or what are we seeing so far?
Well, really fabulous news. This week, the first reunifications began. 4 families. This is the beginning. Yes, we want many more, and many more are coming. What's really incredible about this, and I just want to focus on the humanity of this, the government is acknowledging the harm it did. The government is seeking to provide redress to these families. It is providing ways for them to fly here, not travel overland. It is providing humanitarian parole for the families to come in. And we're not talking just about parents, legal guardians, siblings. They are construing family broadly. This humanitarian parole is for 3 years. This is extraordinary. They are also working with non-governmental organizations and advocates and lawyers to provide the sort of redress that we want, which is social services, social welfare services, mental health, physical health. So they really are trying to provide redress in all ways. But I just want to stop. Like, yes, we want more than 4, but 4 is a lot, and it's more than anyone has done. The government is stepping up, and I might start crying, but this is really where we're going. And the secretary, I was just talking to the executive director of the Interagency Task Force, which was established at the beginning of February, again, through executive order. And as she was saying, dozens more are coming in the next few months. And this is what we want. We have to remember not all families might not want to be reunified. They might not want to avail themselves and return to the United States for whatever reason. They might, and we have to respect that. But what we do have, and this is what's so important in looking at progress, is that the Miss L litigation, there's a steering committee, which is still trying to locate families, right? That committee working with the ACLU has been tremendous. Their remit is only from July 1st, 2017, and only for parents. The Interagency Task Force is all of 2017, so starting even earlier, and again, an expansive consideration of family. So siblings, legal guardians. I think that's really important that the government is owning up to that it did wrong, and it wants to provide redress, and they're also considering accountability. We don't know what that looks like. There's not a commitment to that. Right now, what they're focused on is actually identifying families, providing the mechanisms and the means for them to come here, have protection, a legal means to be here through parole, and the sorts of services to help again, they can never be made whole, but to help them with the trauma so they can start to rebuild a life. I think that's very important.
Oh, thank you. That is, as you said, wonderful, wonderful news. To switch now to our more critical lens, though, what are the challenges that we've been seeing so far? What hasn't happened that you had hoped would have?
Well, a lot of things, right? But this is like a mixed bag in this administration, which I think we're going to hear throughout the course of the evening. But a lot of it, to be honest, I mean, again, Amnesty International is known to be a critical voice often, because we are holding a human rights lens, which is often a higher standard than US law. Um, I think the challenge is really, some of it is operational. This is a daunting task. And the fact is, many records are incomplete and they are struggling to find families. Even with the assistance of the Miss Al Committee, even with the people on the ground, they are struggling to find the remaining families. Then there are let's say, processes, particularly legal processes that can hinder, that can slow down reunification, and that's paperwork. So if somebody is an asylum seeker from Guatemala, and they were deported, they were forcibly separated and deported, and they don't have a passport, we want to fly them in. We don't want them to have to travel overland, right? But are they going to go to the Guatemalan government and ask for the passport so that they can come back here and ask for asylum when they're actually fleeing from that country? So this is like, these are the sorts of considerations that are slowing down the process. Also, we need, the government, I think, is struggling with this, providing the broadest set of relief and redress that it can within a legal framework and use of executive authority, which we want and we are pushing hard. For example, we want a pathway to permanent status, including citizenship. We want financial compensation. We want a committed fund to provide services for physical and mental health welfare. This is what we want. Some of this they can set up, some of it, I think it comes down to a political calculation, because if the government is sued, as we've seen with the 100-day moratorium on deportations, this will stop progress. Doesn't mean that we don't think that they should be doing more, but I do think that they're juggling some things that we don't quite understand, in terms of moving faster to provide the sort of redress that we want. Having said that, what I do know, and this is just a fact of life, is we're all lawyers. Right now, the Miss L class, again, that's legal learned from ACLU. The Miss L, the ACLU is in settlement negotiations with the government. So there's a huge unknown around what will that entail, which we hope will be a lot of benefit to the class members of Miss L, which will also help the interagency task force. But I think that there are probably things happening behind the scenes that we're not aware of, and can't, or we might be, but we can't quite speak to it. But it's also the government, my sense might be hoping that some things will be negotiated and then it can build on them. That's just my educated guess. I'm not sure, but we do have to recognize that there is a negotiation right now around this very thing. The other thing, and I think it's important, is to recognize that the task force, and some of us here, like Elizabeth, you and I were in government, we understand the government is really huge and it is a machine. And this interagency task force spreads across several agencies and departments with wraparound services. And I think, I mean, Michelle Brane is the executive director. She's a leading human rights advocate. That was a win for the community to have her lead this. But again, this is setting up something brand new and they're still getting it in order. And lastly, I will say, and I know I'm confident Kennji and Aaron will talk about this, we do a lot of work together, is let's just acknowledge there is an institutional culture. A lot of people might welcome this, other people don't. And so there is that negotiation internally. Like literally, you don't want people arriving in the United States and not being admitted or being put into detention, even though they were told that they shouldn't be put into detention. We see those things happen, we read about them. So these are like the sort of challenges that happen. Of course, as I always say, which is why I'm so beloved, understand, but you have to do more and you have to do it faster. So that is our role, is to say thank you and please do more and do it faster.
Yeah. And you pretty much covered sort of a preview of what can be expected or hoped for in the future. Are there any other sort of takeaways for sort of what the next step is, or what practitioners can be doing to support changes?
I'm so glad you asked that. So what we're finding right now, and again, I know I keep saying this, but this will come out through here. Immigration is such a political beast. And everything that we've seen, like with the refugee cap, what the president learned is that you can't break a promise, because there is a deep and broad base of support for refugees. But he thought that they were expendable because of what was happening at the border. Right now, the priority is a pathway for to permanent status, to citizenship, for Dreamers, for Daca holders, for agricultural workers, for TPS holders. That's fantastic. But what this all means is what gets prioritized, what kind of moves down, what gets forgotten. And so we don't want family separation to be forgotten. And we might think that that might not happen, but media cycles change and priorities change. And so we need to make sure that we as advocates and also as lawyers make sure that we continue to advocate for this issue, but also the individuals who are impacted. And there are organizations who are working on this who I'm sure would welcome volunteers. But in terms of a lot of this is coming out of the executive, we also need a legislative solution, and that would be the Families Belong Together Act. What we really need, and that was put out by Senator Blumenthal and Representative Castro. This is very simple, like true activism. We need more co-sponsors for this bill because it doesn't provide everything, but it's a good start. Permanent status, people are reunited in the US, redress in terms of support services. We need more co-sponsors. We need it to move to the floor, and we need it to get passed, because we need a form of permanent protection. Because as we've learned so well under the previous administration, anything done through the executive can be vulnerable to court's interpretation and to the next administration. So we want to make sure that we pass this bill. And so that's actually something looking ahead where we really need support. And I will put these links into the chat box.
Thank you. And Denise, I know you'd mentioned to me before that you wanted to potentially briefly touch on refugee resettlement and community sponsorship, as well as potentially other children's issues. Anything else you wanted to say on those issues before we move on?
Sure, I'm so glad. So one of my things that I'm really impassioned about is refugee resettlement. And again, thank you for previewing that. I mean, again, we should have never been in this position to have to fight for the president to keep his promise of a refugee admissions goal of 62,500 for this year. What we can see from this is that we actually flexed our power. And now he understands that there is a broad, deep bench of support for refugee resettlement. And now what we need to do is make sure that this administration understands that they can do it, because they keep saying that they can't. We're like, no, you can. Resettlement agencies can. And we're here to help support and make sure you understand you need to do everything you need to in terms of resources, move with speed to get there. Also, to set the next refugee admission goal for 125,000. That's the next test. That's what he promised as a candidate for his first full year. But I want to really put something positive here. I work a lot on community sponsorship, and people might know that through the Canadian model, where individuals come together to directly sponsor refugees. The administration has really invested in this. And so Secretary of State Blinken, when he commented on the renewed commitment to admitting up to 62,500 refugees this fiscal year, also commented on the administration's commitment to innovation through community sponsorship and starting a private sponsorship model. And the reason that's so important is that talks about building even more welcoming communities across the US and really investing in a deeper bench of advocates in everyday communities. We are working closely with the administration to help shape this private sponsorship model, but we hope that beginning next year, there will be a pilot along the Canadian model where people can come together and directly sponsor refugees. And so I just want to leave like there is hope and there is movement forward, but it will take sustained pressure because they have a lot of choices and it's a mixed bag.
All right, thank you very much for all of that, Denise. I'd like to turn to Erin now. One of the issues probably most keenly felt by immigrants and their families over the past few years have been the issues of enforcement as well as due process. Could you give us an overview of how things have shifted over the last 4 years and where things stood coming into the current administration?
Absolutely. So when President Biden took office, ICE had become one of the most politicized agencies in the entire federal government. According to Pew Research polls conducted in 2019 and 2020, ICE is the least popular major federal agency in the country that in some polls didn't even get a majority of support. It's less popular than the IRS, significantly less popular than the IRS. And we saw the previous administration really use ICE as its mouthpiece on anti-immigration policies and anti-immigrant actions, including appalling behavior such as putting up wanted billboards in swing states ahead of the 2020 election, carrying out highly publicized immigration raids in so-called sanctuary cities, and in many ways acting as a political arm of the Trump campaign in 2020 at a point when they had essentially fired every career service person inside of the agency and replaced the leaders with a series of rotating doors of increasingly anti-immigrant people at the top of the agency. Indeed, there was not a single Senate confirmed head of ICE during the entire 4 years of the Trump administration, and we are now going on nearly 5 years since anyone has gone through a confirmation process to be head of ICE and has actually made its way through. Since Director Saldana left ICE at the beginning of the Trump administration, the agency was run by a series of acting officials, and the person running ICE today is Tay Johnson, who is formerly the head of ICE's detention operations, who has made his way up to the top of the agency after all the politicals left. But despite everything that ICE did in the last 4 years of the Trump administration to target immigrants, from increasing arrests of so-called collateral immigrants, those who are simply standing around those ICE is targeting, to carrying out widely publicized workplace raids, including hundreds arrested in Mississippi and Tennessee, disrupting entire communities in some places, leading to entire schools where almost every child knew somebody whose parent had been picked up, and expanding the agency's deportation apparatus. ICE actually didn't ever manage to deport anywhere near the number of people that President Obama did in his first term in office. In President Obama's first term in office, 2009, 2010, 2011, every year, ICE deported more than 200,000 people that it picked up inside the United States, so not counting those it picked up at the border. The Trump administration never hit 100,000. The highest they hit in a single year was 95,000. So in ICE's best year under Trump, they still didn't reach even half the level of President Obama's first term. And that is due to a large variety of factors, part of it to do with the fact that by picking up a lot of people who are collateral arrests, you end up picking up people who are long-term members of the community, who are more likely to fight their cases and have paths to relief. You also saw that the agency struggled with the immigration court backlogs, which grew even higher under the Trump administration because they stopped any form of prosecutorial discretion, which meant that when the agency did pick up someone, it might be 4 years before they ever got to their case in front of the court. And so that led to a situation where ICE sure might be arresting more people and putting them into court, but those people are simply now being placed into the 1.3 million case backlog. And many of those people, if they didn't give up early on in their case, if they actually had a form of relief that they could pursue to the end, most of the people picked up by ICE under the Trump administration are still in the court process today because the backlogs are so long. But what the Trump administration really was successful with ICE was the expansion of immigration detention to the highest level it's ever been. ICE expanded across the South in particular, opening up multiple new detention centers, usually private prisons in Louisiana and other places along the South. And that led to, in fiscal year 2019, in August of 2019, the highest level of ICE detention we've ever seen in this country. At one point, 55,000 people held in civil immigration detention. The majority of them at the time were asylum seekers who ICE should have been releasing under their own parole guidelines that they refused to change and yet ignored. And that was sort of the top of the detention monster that really we saw under the Trump administration. There was also further expansion of detained immigration courts because all those people were seen by immigration judges in detained settings, and you saw an increase in video hearings with the creation of so-called immigration adjudication centers at the Executive Office for Immigration Review, the immigration court system, where immigration judges in Falls Church, in Virginia, and in Fort Worth, Texas, sit in an office building and hear cases every single day, never seeing a person in front of them except on a video screen. Now, we've gotten used to this over the last year of the pandemic, but now imagine that you're a judge who will literally never see a person that you're ordering deported or allowing to remain in the country except through a video screen. That is in many ways the way that the immigration court system was trending under prior Director McHenry. And there's a lot to be concerned about that and how that's going forward. So that brings us to, now ICE detention levels plummeted last year, in large part due to the pandemic and border closures. The number of people sent to ICE detention from the border was the lowest level it's ever been, thanks to Title 42, which Kennji is, I believe, going to talk a lot more about. And for a period in 2020, ICE stopped arresting most people except those they could pick up at jails and detention centers, and did not do any at-large arrests in the community for pretty much all of summer 2020. That resumed in fall of 2020 when they fired one of the only remaining non-political career acting directors at ICE and replaced him with a guy who had literally no immigration background other than the fact that he had been appointed as head of ICE Office of Principal Legal Advisor in February. One of the highest levels of promotion, he entered the agency in February as head ICE lawyer, despite having no immigration background. This is Tony Pham. And then by August, they made him head of ICE. And then he was gone a few months after that and replaced with another person who had been made head of ICE Office of Principal Legal Advisor a few months after that. And then that person was gone within 2 weeks. So when the Trump administration took office, ICE is in a chaotic state. The agency has gone through multiple different leaders with different priorities going through there. They were never able, they are the least popular agency in the country, hated by many. There's a strong desire to rein the agency in on the left, and indeed many in the center, is shown by a majority of Americans do not support ICE. And so the need for reform after the last 4 years of the Trump administration has never been higher.
That is a lot to take in. And thank you for that excellent summary of where things had gotten to. What have we seen changing so far this administration? Have there been any improvements from your perspective?
So the Biden administration began by following through on a campaign promise of no deportations within 100 days. Unfortunately, that was very quickly blocked in court. And for reasons that are not 100% clear, but I think have to do with the fact that it was a Trump-appointed judge in the Fifth Circuit with a conservative Supreme Court, the Biden administration has chosen not to fight that decision at all. They haven't appealed. I think they maybe filed a notice of appeal, but they haven't sought any emergency relief and have effectively caved and not gone forward with their deportation promise. But along with that did come enforcement priorities, new interim enforcement guidelines, as they call them, which called for ICE to arrest fewer people, detain fewer people, and exercise prosecutorial discretion in favor of those of certain individuals who were supposedly not recent entrants, individuals who had been in the United States since November 1st of last year, as well as individuals who didn't have a certain criminal record that the ICE considered to be a public safety risk, and certain people with terrorism or espionage related claims, which is a very, very, very narrow group. These new priorities are, I would describe them as better than President Obama's priorities, but not good enough. They are actually the second round of interim enforcement priorities that ICE rolled out after some ones that were in effect for only a few weeks through most of February, are not as good as those early ones. They have higher bars for who is determined to be a public safety threat, or sorry, a lower bar for who is determined to be a public safety threat. So more individuals with criminal convictions are swept within them. And they have been, according to reports on the ground and from advocates, and I'm sure many of the people in the audience know this, inconsistently applied is, I think, the best way to describe it. Many people report that their clients should not be a priority, and yet ICE is refusing to do things like administratively close the case, terminate, agree to release on their own recognizance, or take an ankle monitor off. Things that should fall within these ICE guidelines are just not being done. The Biden administration has created a file review process where you can escalate claims to headquarters because they are aware that local offices are not following the guidelines particularly well. But even that file review process is supposedly inconsistent because it's still being done by career staff at headquarters who I think are slow to get with the new program. So we are seeing some positive changes. On the other hand, detention levels are slowly creeping back up as more people are being sent to detention from the border. But many of those sent to the border are going to detention and then being released. ICE releases are also going up. And we are seeing significantly fewer people arrested inside the country by ICE. ICE arrests are half of what they were before President Biden took office, and internal deportations of people picked up by ICE are also about half what they were before President Biden took office. So the agency has been, I would say, reined in somewhat, but there have been no permanent changes yet, and we still have, they've already blown past their 100-day deadline for a promised full review of ICE enforcement under President Trump that was supposed to have been released at the 100-day mark last week. It's now 100 days and counting, like 104, 105 days and counting, and we still don't know what's going on with that review. We hope to get something answer on that soon, but so far they have been silent about it.
And you've already mentioned a couple of the areas where there are things that that were expected or that were hoped for that haven't happened, such as that additional guidance you just mentioned. Are there any other things that have been challenges that weren't expected or that have been frustrations along the way?
I think a lot of people expected the agency to move a bit more aggressively, certainly in the immigration court space as well. There are a number of decisions that the Attorney General could issue right now to make the life of immigrants more easy. On the asylum front, that would be lifting matter of AB, matter of LEA, and others. As procedural matters, Attorney General Garland could lift matter of Castro Tomb and restore administrative closure as a prosecutorial discretion tool around the nation. Indeed, we're still seeing this issue work their way through the courts. For those who haven't seen, earlier today, the Third Circuit ruled that overruled a matter of Castro Tomb and restored admin closure in the Third Circuit, joining the Fourth and the Seventh Circuits. So while the Biden administration sort of goes through the process of dismantling these things that they've said they'll dismantle, people are still going through their cases, even though the administration is aware that the urgency is there. We haven't really seen them focus on making the kind of necessary changes to fix the politicized immigration court system or really to understand the urgency of the cases of many individuals who are having to go through this file review process. We sent a letter, my organization, along with many other organizations here on the call, sent a letter to the administration calling for ICE to be the ones doing the case file review. Under the current system, it's really on the immigrant and their attorney to raise an objection to the government and say, hey, I'm not in the priorities anymore. But that shouldn't be the duty of the immigrant to determine that. It should be the duty of ICE to go through every person who's in detention and say, should we release this person or not, because they're no longer a priority. They have not done that, which is frustrating. And that means that there are still people stuck in detention today who are not priorities under the new memo, just because they haven't raised that to the right person. So I think when it comes to immigration courts and to ICE enforcement, there is a lot left to be done. With 1.3 million cases in the backlog, the Biden administration is going to have to do something to clear that. And it's got to be more than just hiring new immigration judges. It's got to be another round of prosecutorial discretion, but bigger than what we saw under Obama. And yet, so far, it's crickets out of the administration on immigration court issues. So I think we are all really waiting to hear what they're going to do. They have just now gotten a full slate of people confirmed from the Senate, with Vanita Gupta in place as well as a Deputy Attorney General, and Lisa Monaco as well as head of DOJ Civil. So we hope now that the top players are in place at the DOJ, we're going to start seeing some movement on the immigration court issues. But we're here more than 3 months in, with a lot of us sort of staring blankly at them saying, come on, it's time to do something. And so we hope that starts changing sometime soon.
And I think it's a very similar to answer to what you were just saying, but you touched on the immigration courts, and obviously something near and dear to my heart, as well as something that the New York City Bar Association has taken a very strong stand on, is promoting the independence of the immigration courts. Would you mind just sort of touching briefly on where that movement is? Speaking, of course, for those who are less familiar, the immigration courts are currently are administrative courts that are within the Department of Justice, and so the Department of Justice is adjudicating these cases.
That's right. And the last 4 years, with the Trump administration's efforts to politicize the immigration courts and strip the system of even the few due process protections that were there, turning them into, as the head of the National Association of Immigration Judges, Ashley Tabador, no longer head, she's now working at USCIS, said, that they've been turned into assembly line deportations under the Trump administration. And that is not what we want to have as a description of a system that is supposedly independent and neutral. And yet that was what the Trump administration really aimed for the system to do. So the last 4 years have seen a huge blossoming of support for the idea of taking the immigration courts, which are sort of by historical accident part of the Department of Justice, and turning them into a full Article I immigration court system, like the tax courts or the bankruptcy courts, where judges are insulated from political pressures. And I like to say about the system, it's not going to solve every problem. A bad judge is going to be a bad judge, whether he's got independence or she has independence or not. Judges that deny 100% of asylum claims today are not going to suddenly start granting more asylum claims if you insulate them from political review. But what you would get is some way to pull back from this, the wild swings in the system we have right now, and an opportunity to build a system that has more protections built into it inherently, better opportunities for due process for all, and better opportunities for a system to develop free from political interference every time the presidency changes hands. And so Congress has talked about, debated this. There is a pending bill to turn it into Article I immigration court. It's not on the high on the president's agenda, unfortunately. We had hoped in the U.S. Citizenship Act, which was his comprehensive immigration reform bill, that Article I courts would be part of that. It was not. In fact, literally the only immigration court, basically the only specific structural changes to the immigration court in the U.S. Citizenship Act were more judges, more support staff, the same thing we have seen over and over and over again. But as I like saying, you can't just throw judges at a 1.3 million case backlog and expect to make any real difference. The previous administration tried that, it didn't work. That is also, to be totally honest and fair, partly due to COVID, which has led to the courts being shut largely for the last 13 months and counting. New York City Immigration Court remains shuttered today to new cases, and in many places around the country, they're not having initial master calendar hearings. So if ICE picked you up in April of 2020, there's a good chance you've still not had your first court date, depending on where you are in the country, and you might not have a court date coming anytime soon. And so at that situation, you really need to start talking bigger structural changes and a path to citizenship, something that will actually clear the backlogs by granting legal status to most of the people in it. So I think when it comes to the immigration courts and turning them into an independent court, I think there's a lot of support for that, but it has to come along with other things than just that. Congress reining in ICE through the appropriations process, cutting ICE's budget, reducing the ICE detention levels, restricting ICE from carrying out certain activities through the appropriations process as well. And I think that's going to be something that's going to be really important to keep an eye on the president's budget, which is coming out formally later this month. We've already seen a skinny budget that the president put out that had nothing to say about ICE detention, which is both a good thing and a bad thing. It means they haven't made a decision yet. It's bad because it doesn't mean it wasn't something that they felt was a high enough priority to highlight in the skinny budget. So we hope that when the president's budget is released later, we're going to see some reduction in ICE detention levels in there, but stay tuned. I think that's coming out in a few weeks.
And you've just run through for us some of the kind of what we should expect coming soon. Are there any other things that people should be keeping an eye out for, or next steps that people should be considering getting behind?
Yeah, so I think the big next thing to wait for is the ICE new final priorities that are supposed to come out, and there's supposed to be a full review of the immigration enforcement apparatus that President Biden, I keep saying President Trump, that President Biden ordered a full review of immigration enforcement in the first 100 days. What that results in, what that means for ICE is going to be hugely important and may shape the agency for the next 4 years going forward. We hope that it's going to be as sweeping as it promises and make some real change. I would also flag that Republican states are very aware that the Biden administration has a lot of authority here, and 2 separate lawsuits have already challenged the priorities. One in Florida, and I think Texas has challenged it, though now that I'm thinking about it, maybe only 1 lawsuit, but there is a currently pending lawsuit about the ICE priorities. And if that gets a judge who decides that it's time to interfere, it's possible that we could see the ICE priorities struck down or somehow reined in by a federal judge, which means that the handcuffs will be back out for immigrants and off of ICE, which is where they are now. So I think keep an eye on those lawsuits because they could stop the forward progress, and keep an eye on the new ICE priorities that should be coming hopefully any day now.
All right, thank you so much for all of that, Aaron. For our next 3 speakers, we're going to be looking at it at humanitarian, family, and business immigration law, respectively. I'd like to turn to Kennji first to talk about humanitarian issues. This is obviously a very broad area of law that covers everything from asylum to victims of crimes, to temporary protected status. Kennji, I know it's impossible to cover everything, but what was the state of the law generally heading into the current administration?
Yeah, I'll just try and touch on a few of those areas. I think, principally on asylum, the system was really decimated by the Trump administration. And as others have said, all of these changes were accomplished through executive actions or regulations. We really didn't see any legislation that affected these areas, which is in turn, a source of hope, because it means that these things can, with the administration that's willing and interested, be quickly rolled back in some ways. But on asylum, so, from day one, asylees and refugees were really an area of sustained interest and attack by the Trump administration. So we really started the Trump administration with the Muslim ban, really, within hours of them taking office, trying to ban people based on their country of origin. And it really continued from there. We saw, in terms of asylum, bans on people who had crossed the border between ports of entry seeking asylum, which is very clearly permitted under US law in the statute. They instituted, of course, the zero tolerance program, which affected a lot of asylum seekers. There was the third country transit asylum ban, which barred asylum seekers who had passed through third countries on the way to the United States, including, of course, people who had passed through Mexico. And that resulted in many people being deported during the credible fear process and also denied asylum on the merits. We had, of course, the programs to externalize asylum, so a policy of returning people to Guatemala under the asylum cooperative agreements. Agreements were also signed with El Salvador and Honduras, but none of those transfers were ever actuated. There was the migrant protection protocols that saw some 70,000 people return to Mexico, many of whom ended up abandoning their cases out of fear, many of whom were kidnapped or assaulted, and very few of whom actually received protection through the program. I think in the end, there were only 523 grants of asylum through the migrant protection protocols. And they also really froze, as Aaron was mentioning, with the pandemic in March of last year, when everything else shut down. And that led us to the COVID-19 restrictions. The use of Title 42, which is a public health authority, and an order that was issued by the Centers for Disease Control and Prevention that effectively shut down asylum protections at the border. And left most people either blocked at the border or being summarily expelled without any access to the US asylum system or even a fear screening, expelled either to the country they were fleeing or to Mexico. On the other fronts, really sort of like at the turn of the administration, there were a number of cases pending before the Supreme Court on a number of these issues. So there was a challenge to MPP, there was a challenge to the border wall, a challenge on TPS because of the circuit split in terms of whether TPS is considered inspection and admission for purposes of adjustment. And there was a challenge on the availability of bond for people who were in reinstatement of removal proceedings. So we can kind of talk about what happened with those cases. It's sort of a mixed bag of where those went. And then, of course, there was the ongoing litigation around the legality of Daca. And there, of course, had been a very good Supreme Court decision, but there were still pending cases on the legality of Daca, not just the legality of the termination. And that case, of course, is still pending at the district court level. And we had, I'm sure as you'll hear from others, the growing backlogs of applications with USCIS in many areas, in addition to the massive backlog in the immigration courts. So as we stand right now, there are almost 400,000 pending applications with the Asylum Office. The U backlog is approaching 300,000. There actually was some movement during the pandemic to actually clear the backlog of I-360s for special immigrant juvenile status. I think that's one of the few areas where they seem to make progress during the pandemic. But of course, I think across the board, the policies the administration put in place, despite their rhetoric about trying to increase the number of deportations, actually grew backlogs, actually slowed down processes, and resulted, of course, in many, many challenges that blocked many of the policies the Trump administration tried to put in place, and sort of locked up the department in litigation repeatedly. And often resulting in losses at every level for the administration, for the Trump administration. But anyways, that's sort of the, the broadest, simplest sketch of sort of where we stand on asylum. And it's sort of maybe more hopeful to talk about like where we're going and what we haven't seen yet. But.
And take it away with that. Let's get into that more hopeful narrative.
Yeah, so I mean, you know, the president issued a number of executive orders early on in the administration in early February, and they outlined a number of areas that were up for review or policies that would be immediately terminated. And some of those were great news. So on the asylum front, there had been, I hadn't even mentioned these, 2 programs that were to conduct asylum screenings, fear screenings, while people were held in CBP custody at the border. And these had initially been sort of sold as sort of fast track deportations. But in fact, what ended up happening is that people were held for weeks at a time in CBP holding cells, Border Patrol facilities, waiting for these interviews. And of course, we know the conditions there are really terrible, and there's very extremely limited access to counsel. And so those programs resulted, again, in extremely high negative fear determination rates and most people being deported. And so that executive order immediately ended those 2 policies, although frankly, they hadn't been used because of the pandemic anyways for a number of months. The order also instructed the State Department to terminate the agreements with the 3 Central American countries that had entered into the asylum cooperative agreements, these transfer programs. And it directed an end to the migrant protection protocols. And that, of course, has actually started and has sort of similarly to the family separation task force, started to bear fruit in a major way. And so I think probably by now about 10,000 people have been transited out of MPP from Mexico into the United States. The vast majority of them have been released on parole. They have not been detained. They've not been placed on restrictive ankle monitoring systems. So that's really great news. And the executive order also directed the Department of Justice and Department of Homeland Security and others to review a number of other policies, including protections for asylum seekers who are fleeing domestic violence and gang violence. It directed the issuance of regulations related to particular social group claims. It also directed a review of expedited removal, although a little less clear what exactly the scope of that review is. And so all of those are still ongoing. We haven't seen any action on that. And, you know, as Aaron was mentioning, the Attorney General has the power to issue, obviously, rulings. And one would expect that the outcome of that review of gang and domestic violence claims would be some decisions issued by the Attorney General, which would overrule some of the most restrictive of the Trump administration AG decisions in those areas. One of the major things that has stuck with the Biden administration is Title 42, this policy of blocking asylum seekers at the border under this pretext that shutting down asylum processing is a way to protect public health. And our organization and many others have worked hard to try and combat what we think is really a pretext of the Trump administration. And reporting on the issue over the past year has showed that the decision was a political one, that CDC was forced to issue this policy over objections of its own experts. And public health experts have repeatedly explained why it really has no public health justification. So the border remains open to people who are crossing for work and for school, for transporting goods, and at the same time, the relatively much smaller number of asylum seekers who are arriving are blocked at ports of entry or being expelled. And I think one of the most devastating continuations of the policy is to see that in the first 100 days, the Biden administration carried out, I think, 30 deportation or expulsion flights to Haiti, mostly of asylum seekers, people who were not given any opportunity to access the asylum system, no fear screenings, all returned to Haiti at a time when the country is in major turmoil because of the political situation there. And the department's own internal memos really showed that they understand that they're returning people to potential harm. And yet they've continued those flights completely unabated over the past 100 days. And it is really remarkable that they've done that. The Secretary Mayorkas last week appeared on a panel at UCLA and talked a little bit about some of these policies, where they're going, why we haven't seen movement on these, and made some statements about where the department is heading. And one of those is on temporary protected status for Haiti, Cameroon, and Mauritania, which were not issued by the administration. There was a designation of TPS right for Venezuela early on, after the Trump administration did deferred enforcement departure. So, there was some movement from the administration on that, but it has been a very mixed bag on asylum protections and on issues for people who are, sort of arriving at the border or fearing harm on return to their country. It's been, frankly, it's been really disappointing. It's great to see MPP being wound down. It's been, as Denise was saying, too slow. We want to see it faster. We want to see more. And unfortunately, the criteria for who's eligible to be transited out of MPP is still pretty limited. We think there might be a next phase that would include more of the people who were unfairly denied protection or ordered removed in absentia or had their cases terminated because of procedural issues with the NTAs that got some of the immigration judges riled up in San Diego and led to like more than 10,000 cases being terminated. But at the same time, they just haven't been very transparent about what they're planning, what the next steps are, and that's been really difficult for asylum seekers who are stranded in Mexico, who really don't know what's coming next, and is leading to more confusion and danger on the border as people start camping near ports of entry, as was happening before. We're sort of returning to the situation when the Trump administration was metering asylum seekers at the border. There are maybe 2,000 people sleeping at the port of entry in San Isidro, hundreds of people in Reynosa. The only reason there isn't a camp in Matamoros, again, is because administration's basically been expelling people by plane to other ports of entry to prevent that situation from recurring after they cleared the camp of asylum seekers who were in MPP. Anyways, I could go on forever. I'll cut it off there, but that's the sort of sad state we're at now.
And so, keeping all of that in mind, what are sort of the next steps that you're hoping will be seen moving forward?
Yeah, so Aaron mentioned the U.S. Citizenship Act, which did have some great provisions. Obviously, there is the path to legalization for people with TPS or DACA, and there are also standalone bills on that, legalization bills for farm workers, for essential workers. Whether any of those have any real chance of becoming law, is an open question and is perhaps dependent on trade-offs that are being put forward by other senators and representatives in bills on border security. That's often, what's been put forward in the past is a trade-off for legalization, is more restrictive measures on asylum seekers and at the border. So we'll see what happens in those negotiations, but there have been some good signs from the administration about their priorities. So they, in the U.S. Citizenship Act, proposed to eliminate the one-year filing deadline for asylum, which is great. There was also, in the skinny budget that Aaron was mentioning, there was more money for USCIS officers to adjudicate asylum cases. and the naturalization backlog, which we know is, I think, close to 1 million cases at this point. So those are good. Those are very much needed, and there's lots of reforms that can be put in place at the asylum office and at the immigration court level that would help to speed up asylum matters, which of course people want because they want to be granted protection and not be left in limbo, cut off from their family members abroad. And there are other less good positions the government has taken. Unfortunately, in the TPS litigation before the Supreme Court, the administration did not ask for that to be placed on hold like they did for the MPP and border wall litigation. And they did not reverse the position that the Trump administration had taken, which is that TPS should not count as an admission for purposes of adjustment. So that case was heard by the court and is pending decision. So that was really disappointing to see, because that would also, of course, help clear some of the backlog from the immigration courts if people with TPS were able to adjust through USCIS, and help to clear some of the backlog at the asylum office, where there are tens of thousands of folks who were probably seeking to get cancellation of removal. And there are sort of other ways that if the administration were willing to view some of these applications that are really meant to get people a way of applying for alternative forms of relief out of these backlogs would help to alleviate the long delays. I think we expect to see a Refugee Protection Act reintroduced probably in the next month and a half. And that's something that people should get behind. That was last introduced in 2019. And it really tries to encapsulate all of the reforms that advocates would like to see around asylum. So I think that's something to look forward to. And of course, there have been many other pieces of legislation on different parts of the asylum system, on border processing, on detention, on family separation, as Denise was saying, that are already introduced in the legislature, and that would be great to support. And then I guess the other thing is just the sort of general plea that people continue to take on asylum matters and other humanitarian cases despite the extreme delays. That of course it still makes a huge difference for people to have an attorney, and even when it takes 5 or 6 years, it's worth sticking around on those cases and making sure that people are represented, because as we all know, it's become increasingly difficult to present an asylum claim successfully. The denial rates really continue to rise every year throughout the Trump administration. So having a lawyer still makes a big difference. And it is, like, frankly, I think harder and harder for pro bonos to take on those cases because of those really long delays and the inability to really plan around when their cases are going to be heard. And people aren't willing to take on as many cases because they do take 5 or 6 or 7 years to resolve, and that's even when things are moving as quickly as possible. So.
Yeah, and I'll mention related to that, another piece of legislation that's out on the table at the moment, the Fair Proceedings Act, which would hopefully provide appointed counsel to a lot of at-risk populations, as well as low-income families, because for anybody on the call who's not familiar, there currently is no right to appointed counsel in immigration court, even though the stakes are often life or death compared to, misdemeanor criminal case. There's no right to counsel. So,
and there was a provision in the U.S. Citizen Act on that as well, on the counsel point. Not as expansive, I think, as the bill, but still a good sign that the administration was willing to include that in its bill.
Thank you so much for that, Kennji. I am next going to shift the conversation to family-based immigration law with Charles Wheeler. Charles, what are the big issues that have emerged over the past few years in family-based immigration law?
Well, I would say that Stephen Miller and Trump actually are very successful in shutting down family-based immigration, or at least the better part of it. Collapse is kind of the word I would use, or unholy mess. I think it's what Trump really inherited. Part of this, of course, was COVID complications and using that, I believe it was Aaron or Kennji who said, as a very effective pretext to stopping immigration, but that was their stated goal, and I think they did a really good job. Some of the things, I mean, I could really talk the whole time on what Trump inherited, or what Trump tried to do with attempted fee increases, with restricting fee waivers for a lot of applications. Obviously, the Muslim ban. The big one, though, really was proclamation, I forget the number, but basically restricted any immigrant visa processing except spouses and unmarried children of US citizens. So that, coupled with the fact that for the better part of a year, consulates were effectively closed, meant that the backlog now has continued to grow to really an astronomical level. With the consulates starting to reopen, you're getting some anecdotal information about how those interviews are proceeding. So that's good news. But again, they're talking about trying to reschedule interviews that were scheduled really over a year ago. So that's where things have collapsed, I guess. Other things that Trump tried to do, there was a health proclamation saying that unless you had verified proof of health insurance, or that you were going to get it within a certain period of time, you weren't going to get an immigrant visa as well. Many of the attempts that Trump tried to do were blocked by the courts, or at least slowed down, as we know. The biggest one, though, really was, of course, the public charge rule. And for the better part of his administration, that was his signature effort to try to either scare people away from getting needed public benefits for their children, their spouses, but also discouraging them from even attempting to file for an immigrant visa or adjustment of status. With a public charge rule, really sort of two-headed, one by DHS and one for Department of State, expanded the list of public benefit programs that if the applicant had received, then they were going to essentially be barred from entering as a permanent resident. But really more importantly, taking, and this was very creative on their part, taking the 5 statutory factors that were already in there since what, 1997, 96, but enforced in 97, that indicated that the intending immigrant's age, their health, their financial status, their education could be considered as part of the public charge analysis, this totality of circumstances. And what Stephen Miller, I assume, gave him most of the credit, was successful in doing is to define those terms in such a way that unless you had English proficiency, at least a high school diploma, certain work history and job skills that you'd built up, income of at least 125% of the poverty income guidelines, positive credit score, an age that fell within a certain bracket, and proof of health insurance, you were basically had negative factors that would probably likely, if they amounted to a certain number, keep you from getting an immigrant visa. It was the prime reason why so much litigation was filed and successfully fought for really 2.5 years, resulting in several district court injunctions on one day. In fact, there were like 5 of them. Those were either stayed or overturned, stayed by courts of appeal, stayed even by the Supreme Court, leading up to, and this is really quite amazing, the timing of this. One district court in Chicago had issued a permanent injunction finding that the rule was unconstitutional or illegal and vacated the rule itself. That, of course, was stayed. But on March 9th, a day that will live in infamy, I'm sure, to Stephen Miller, there was this, I guess you'd describe it as a blitzkrieg effort. And I have to say that this sort of went under the radar for a lot of people because what had happened was Biden had campaigned mentioning the public charge rule as this thing you needed to get rid of. But then coming out with this limp little statement about 30 days into his presidency saying, well, we are going to analyze the public charge rule and we're going to have the agencies do an investigation and lead to some report by some committee or something. And we're all going, no, it's do more. And I don't think that they realized the posture of these cases because the Supreme Court during Biden's time accepted cert on the Ninth Circuit case and was about to move full speed ahead to essentially sanction or give authorization to this terrible radical effort. So a lot of pressure was put on DHS, was put on Senator Schumer's office, a number of people, Mayorkas then come in as DHS head. And in one stroke, on March 9th, they not only dismissed the district court decision, they appealed a district court decision in Chicago, but also moved to dismiss the Ninth Circuit appeals, the Second Circuit appeals, and the writ of certiorari of the Supreme Court. And lo and behold, and I wasn't really aware of how easy it was to dismiss an action if you had brought it or an appeal. This is simply a clerical effort. Within 15 minutes, the Seventh Circuit had dismissed the appeal, and the public charge rule went into a nationwide enforcement. Unbelievable, very simple. And that led to a ripple effect with all of these courts of appeal eventually very quickly dismissing it. That was followed up by DHS withdrawing the public charge rule from the Code of Federal Regulations, reinstituting the policy manual defining public charge in a narrow way. Meanwhile, on a separate track, the State Department had been enjoined since July from enforcing its public charge rule. And lo and behold, that had not been stayed. So you had an injunction already in effect for 6 months. But State Department under Trump issued a foreign affairs manual that went back and restored a lot of the wonderful language, redefining public charge in a way that really shifted the focus back on the sponsor, away from the intending immigrant, with a lot of great language saying that a legally sufficient affidavit of support should be all you need in terms of meeting the public charge rule. That if you're able-bodied and employable, there shouldn't be any further question. The intent of the sponsor or the intent of the joint sponsor is irrelevant since this is a contractual obligation. So that was great news. And that was, as I say, probably the biggest thing that Biden has done for purposes of family-based immigration. Did I answer your question?
Yes, you definitely did. And you mentioned that's one of the biggest things that's been done. Have there, however, been any frustrations or challenges so far in the realm of family-based immigration?
Gee, let me think for a minute. Yes, I think there have been. In fact, Kennji mentioned one of them, which sort of this overlaps with enforcement priorities, and it also overlaps with humanitarian relief. And this is the issue of advanced parole, particularly for people with temporary protected status. And Kennji mentioned the Supreme Court has accepted cert. In fact, heard oral arguments a couple of weeks ago in the Sanchez case, which was a Third Circuit case, talking about whether if you have temporary protected status, is that enough? Does that qualify you as being inspected and admitted or paroled? I don't want to go into the whole legal argument, but the Ninth Circuit, the Sixth Circuit, I think the Eighth Circuit had all said yes. The Third Circuit and the 11th Circuit had said no, so obviously it's split circuits. But Biden missed his chance really to withdraw the cert petition. Frankly, Obama missed his chance too, and take really what I think is the plain language of that statute in the INA, which says that if you are in lawful temporary protected status, that is equivalent of being a non-immigrant. They are inspected, admitted, or paroled, et cetera. So he blew it. The Supreme Court is, I can assure you, going to side with the Third Circuit and deny that and come up with a more conservative view. So, but there are still two TPS related issues that can be remedied. One deals with this issue of advanced parole. If you leave on advanced parole and you are in TPS and then you return, you have obviously been paroled back in, not according to a very tortured, twisted interpretation of the miscellaneous technical blah, 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 where they said, well, I didn't want to talk about their logic. I'll just say that with one stroke, that could be reversed, and people who are paroled back in are in fact paroled back in, and they should, if they are what's called immediate relatives, most typically married to a U.S. citizen or have a child over 21, petition for them. And there are a lot of Salvadorans, frankly, in that category since they came in the 90s. They've been in TPS status for what, 22 years now. So you have a whole pool of people who could get their permanent residency here through an I-130 petition filed by their child or their spouse without having to leave consular process, file a waiver, blah, blah, blah. The other TPS related issue deals with, again, regrettable interpretation, which says that if you leave under proceedings, in other words, you have a removal order pending against you, or you're still in proceedings, and you leave on advance parole, coming back in or leaving, I said, does not trigger or execute that order. Why is that a bad thing? Well, if it triggered the execution of the order, then you can file for adjustment of status with the USCIS. You can file a waiver for the removal order, which is a fairly simple process. But now you have to bargain with the trial attorney, the Office of Chief Counsel, try to negotiate some sort of joint motion to reopen, et cetera, et cetera. So until that issue is, I guess, resolved and fixed, and it's happening piecemeal around the country, you're going to see a lot of people who unfortunately can't take advantage of that departure and return. So that's one issue. Also with public charge, it's not over. We're still hoping and pushing Biden to issue a formal rule on this, proposed rule, so we can get some public comments and nail down a lot of the discrepancy now between State Department interpretation and the USCIS interpretation, try to adopt a lot of that good language in the Foreign Affairs Manual, make it less vulnerable to reinterpretation by the next administration. So we're hoping that and it really sort of clarify which public benefits count, which ones don't, who's subject to public charge, who isn't. Right now, it's reduced to the 1999 guidance, which had 3 cash assistance programs only, temporary assistance, needy families, SSI, and then state general assistance. But you still have a lot of people concerned, scared, afraid, confused, et cetera. So I think a lot of public attention on this and bringing it forth, you can't really do enough to educate the masses on this issue. So that would be another thing I would push for. NTA enforcement. Aaron was talked about the ICE enforcement priorities. Really sort of dovetailing in that is this horrible NTA policy that the USCIS issued, which now has been removed, but we're waiting for something that could come and clarify what exactly is their NTA policy. The effect, or the chilling effect, I would say, in the prior policy, the one issued by Trump, was that if you submitted a petition or application, particularly for adjustment of status, and you were found to be denied, maybe a waiver was denied, et cetera, and you were not in lawful status, which is almost by definition most of the people applying for adjustment, then you were issued a notice to appear. So you had a lot of people, obviously, who said, well, gee, do I want to take that risk? And that was really one of the first things you said to a client in the initial interview is, listen, I have to warn you that we are on dangerous times, and do you really want to go forward in this situation? And a lot of people backed off. So removing that enforcement policy, I think, is going to open up gates as well. But you still have huge backlogs. I mean, I can't even fathom how long it's going to take to try to get through all that. You had this nasty extreme vetting policy, and I don't know to what extent that's still in place. Trump was really, I think, championing it even before he got elected, and nobody quite knew what extreme vetting was, but basically taking large swaths of USCIS personnel, putting them in the back room, not adjudicating petitions, but going through details and 15 years of residences and 5 years of social media and trying to look for stuff that may or may not exist. Particularly true with naturalization applications. I don't want to get into that. But if you can redirect and reprioritize USCIS, and obviously a lot of that, the coronavirus and the furloughs cut back in manpower, personnel, but reprioritizing, I think petitions and applications, work authorization, biometrics, application support center interviews. Now you have just ridiculous backlogs that say, you got a client, you're saying, listen, you're married to a US citizen, you entered lawfully. Sure, we're going to file this now. It's a 2-year wait for the petition to be approved in the best of service centers, sometimes 3 years in some service centers. Then we're going to get, it's a 2-year wait for adjustment interviews in a lot of these districts, 3.5 years in Baltimore or Brooklyn. Then you hopefully will get work authorization in about 6 months after filing and get the ability to advance parole. So you get a lot of people saying, well, wait a second, I need to go see my mother, or I need a work authorization now. Another one of the things that the Trump administration did, very clever, under the, I forget what Orwellian term they used, modernization or something, they really restricted access to USCIS district offices. You would think, well, that means they'd be more prioritizing on adjudicating of petitions. No, just the opposite. I don't know what they were doing, but it wasn't doing what they should be doing. And if you're an applicant, that meant that you couldn't make an interview on your own, go in within a few weeks or days, try to see what the status of your case is, try to clear up any discrepancies, resolve things at the local level. Now, what you have is this switchboard that only in, quote, emergencies that they define will you be allowed to go in to a local district office. So restoring access, I would say, through the info pass system would be a great way to allow you to get back into the system. And there's other things they could do as well. The Trump administration enacted this policy that said that the adjudicators didn't have to issue a request for evidence or a notice of intent to deny before denying an application. And if that was based on your simply failing to submit an additional document with an application, that meant that you didn't get an RFE or a NOID, you just simply got a denial, forcing you to start all over again and submit whatever was necessary. That was new, and that was wonderful if you wanted to keep people from moving forward with their case. So reversing that, a lot of simple stuff they could do, and we're waiting for them to hopefully do that. Elizabeth, we can't hear you.
Oh, sorry, I'm muted. Apologies. I was just saying thank you for all of that, Charles. It I wouldn't say it's necessarily uplifting, but gives us all a lot to think about in terms of areas where change could be beneficial. And just to flag for anybody who's not aware, U.S. Citizenship and Immigration Services did put out a call for comments on barriers with USCIS. And so certainly if anyone is with an organization that works on these issues, put in those comments so that they're aware of all of these kinds of challenges that Charles was just talking about.
I didn't necessarily jump up on my chair and applaud when I saw that, because most of the organizations, national ones, have been feeding all sorts of white papers and ways that the Biden administration can come in and do things immediately. So they've got all that information. I sort of saw that as almost a delaying tactic, but it does give us a in terms of saying, all right, what about a public charge reward? What about this, that, and the other? So I'm not really sure what the intention of doing that was, frankly.
No, that's an excellent point. And so now I think I'm going to turn the conversation over to Claire to talk about business immigration law. Before I do that, I'm just going to remind everybody really quickly that after Claire, we're going to hopefully have a little time left for question and answer. So if you have any questions that you want to submit, you can hit that Q&A button down at the bottom to submit those questions, and I'll pose those to the panelists coming up at the end in a moment. So I want to turn things over to Claire now. And when we were preparing, I remember Claire saying it was a little awkward to be talking about business immigration concerns alongside family separation or asylum law. But this is an area that I think really does not get much attention and has a huge impact on commerce, business, and individual people. And we don't talk about it as much, and it doesn't make the headlines as often. It's important to have a whole picture, a full picture of immigration law. So Claire, set the stage for us. What was the state of business immigration law coming into the Biden administration?
Thank you, Elizabeth. Like my colleagues have been talking about, I think even in the business immigration scenario, the Biden administration inherited an immigration system that I think was deliberately decimated by the Trump administration. But in the business context, I think the outlook for change is perhaps a little bit more positive. We're seeing some early on positive changes. I would say the mood swings from frustration and impatience, and like Denise was talking, about, we want more and we would like it faster, to actually seeing, some progress being made. Certainly the prospect for positive changes there. For context, the Trump administration advanced nearly 1,000 policies and rules, most of them restricting immigration. And this created numerous challenges for US employers seeking to hire foreign workers and for universities seeking to enroll foreign students. While our goal is not to return to the status quo of the pre-Trump era, initially, the first order of business has been to stop and reverse draconian Trump policies. Ultimately, business immigration is about the adjudication of benefits. US employers seeking to sponsor workers, foreign students wishing to enroll in universities have to either file an application with the USCIS in the United States or at a US consulate abroad. Between the COVID closures that we've seen and then the Trump administration's hardline policies surrounding immigration, we're really left with operational dysfunction at the agencies. We have backlogs probably in the adjudication of benefits of nearly 2.5 million applications of various kinds, not just business immigration. Businesses really faced, as a result of this, just kind of untenable delays in the adjudication of benefits that might cause them to lose the opportunity to employ a foreign worker or to onboard a foreign student graduate. And at the same time, we saw when cases ultimately were adjudicated, the imposition of standards that I really think exceeded regulatory standards and were quite arbitrary, the Trump administration imposing their very hardline standards. The need for change is dire. I think we are encouraged by the appointment of Secretary Blinken, a career diplomat at the Department of State, and Secretary Mayorkas at the Department of Homeland Security. He was the director actually of USCIS under the Obama administration. So we know that he is at least familiar with the agency's longstanding operational challenges, but it's this kind of seasoned leadership, I think, that's going to be needed top down to make the progress that we need to see on the business immigration front.
Thank you, Claire. And so what are some of the initiatives that you have seen so far taking shape under the Biden administration?
Well, I suppose it's a legacy of the Trump administration that the most welcome thing that we saw was no action on certain items that the Trump administration tried to get in the late days of its administration. So early on, the Biden administration put a freeze on the so-called midnight regulations that were advanced by the Trump administration. And a few of these would have had a very adverse impact on US businesses. One of the rules that was delayed was a Department of Labor prevailing wage rule, which would have significant significantly raised the required wage for green card sponsorship for employment-based immigrants, as well as the required wage for temporary work visas, professional workers under the H1b visa program. Another regulation that was paused relates to the H1b lottery that's held every year. Right now, it's a random lottery, essentially, and the Trump administration sought to replace that with a scheme that would award visas to the highest wage earners. And this really would have had the effect of foreclosing employment opportunities for entry-level foreign student graduates, and also would have severely impacted small businesses who can't compete with the salaries paid by larger organizations. Just a footnote here, these regulations have been paused, but they are by no means off the table. The agencies are taking another look at them, but I don't think they're entirely inconsistent with where the Biden administration stands on some of these issues. At least in the comprehensive reform bill introduced to Congress, there are some provisions in there that would allow the government to reserve visas for higher wage earners. So this is something, that we'll have to keep an eye on if that legislation does go forward, because that would have an adverse impact on businesses and foreign student graduates, I think. I think, another big action early on was the revocation of the Buy American, Hire American Executive Order, or BAHA. So why is that important? Well, the Immigration Service used Buy American, Hire American to move away from its statutory customer service mission and really kind of step up the scrutiny of applications, delay adjudication of application, issue requests for evidence. Again, I think many times exceeding the regulatory standard, all with a view to trying to shut down certain type visa programs, most notably, I think, the H1b for professional workers, and to a lesser extent, intercompany transferee visas that are used by multinational organizations. So unfortunately, in some measure, this persisted early into the Biden administration. But I think there is growing cause for optimism. I mean, in concert with revoking BAHA, the administration did issue an executive order that was talked about earlier about restoring faith in our legal immigration systems. And I will hazard a prediction that I do think that this order stands to have a significant positive impact on business immigration and businesses hiring foreign workers. I mean, a functional immigration agency that facilitates access to statutory benefits is really critical for ensuring that businesses can hire the talent that they need to, universities can attract foreign students. I think this all helps to grow our economy, but it also provides a mechanism for lawful immigration that relieves pressure on the other areas of our immigration system and allows resources to be devoted there. So consistent with this executive order, the Biden administration has asked the State Department, the Department of Homeland Security, to take a look at existing agency action, legacy from the Trump administration, and identify the barriers that impede access to these benefits and reverse policies where appropriate. Just last week, just getting in under the 100-day mark, USCIS took the first step, I think, in the right direction by reinstating a 2004 memo that instructs adjudicators to give deference to prior agency approvals. I think this will have a very positive impact on kind of eliminating some backlogs and achieving more efficiency around adjudications. Without the deference memo, we were faced with situations with foreign workers employed by a company in the same job for years, children enrolled in school, they have a home. When they sought to extend their benefit, the Immigration Service was looking at the petition de novo and imposing frankly absurd levels of scrutiny, and in some cases denying these applications, leaving the employer with an interruption in their kind of workforce continuity, but also the family having to, get out of school, leave the home, depart the United States on very short order. I mean, we have had families have to go back home to countries where COVID is raging. I mean, it's just a horrible, horrible situation that stems from, I think, just these kind of hardline policies that some adjudicators are still clinging to. So restoring the deference memo should really help in that respect. But I think it's also going to help the agency, because what's been happening is USCIS is a fee-funded agency. It's collecting one fee to adjudicate an application benefit, and it is spending more time and more officer resources on adjudicating that one benefit, and they're not getting any more money from that. So in the meantime, the backlogs pile up, staffing is in crisis mode, and the agency is just, in fiscal in dire straits. So I think restoration of the deference memo will help all around. Other actions, I'll try and run through them really quickly. Rescinding, the administration rescinded a Trump memo or regulation that would have eliminated work authorization for certain H1b spouses. So this would have also been disruptive to the employers that employ these individuals. Withdrew a Department of Homeland Security rule that would redefine what is a professional specialty occupation for purposes of the H1b visa. Withdrew a Department of Labor rule that redefined employer, another restriction that was aimed at the H1b visa program. Declined to extend the Trump, what I call visa bans that were implemented under the guise of COVID, if you will, but they were really aimed at restricting the admission of intra-company transferee workers, professional workers, seasonal workers, and some exchange visitors like academic scholars and postdoc researchers. So the Biden administration let that visa type ban expire on March 31st. My colleagues have referenced the Muslim and Africa travel bans, public charge, restoration of the Daca program through executive order. All of these also very much welcomed by the business community. Of course, businesses employ individuals impacted by all of these really horrible policies. So we very much were glad to see them go. And finally, I would applaud the introduction of comprehensive immigration reform. I don't know if we'll get there, but it's a good sign that we can take a look at this holistically and hopefully, raise everyone's boats as we, navigate these waters.
Thank you, Claire. That was all, a really interesting, from someone who practices less in the business area, it's really interesting to hear all the little progresses that are being made, as well as some of the challenges. Are there any other sort of frustrations or big things that haven't happened yet that are in the business immigration law area?
Yes, we have lots of frustrations. Thank you for asking, Elizabeth. I would say it really goes again to the operations and the operational dysfunction that we've all talked about and we're all feeling within the areas of our practice. So if we're looking at the agencies that adjudicate benefits, looking at the US consulates abroad, with COVID, most of the consulates had to shut down and due to staffing shortages and local quarantine requirements, just had to cancel thousands of visa appointments. And then on top of these consular closures, we had the Trump administration implement some regional travel bans based on the COVID situation in the various regions. That basically said, if this individual has been in one of these regions in the 14 days preceding entry to the United States, they cannot be admitted to the United States. The countries covered are Iran, China, Brazil, Schengen area, United Kingdom, Ireland. The Biden administration added South Africa to the list, and most recently, just this past week, India. Now, I have no quarrel with the public health consideration here in terms of just, having to be very careful about how we proceed as we start to emerge from the pandemic. The problem is that many of the consulates have interpreted these regional bans on admission to the United States as we're not going to even adjudicate the visa application for these individuals if you're in this region, because you can't be admitted to the United States just yet under the ban. I mean, the problem with that reasoning, well, two problems with that, that's just compounding the backlogs that are already, there for visa appointments. I think about 71, look at my statistics here, about 71% of consulates are still, not operating at full capacity, and only about 40% are handling anything other than, emergency appointments. So by not even adjudicating these visa applications, we are just adding to backlogs, and many people cannot get an appointment before 2022. So that's an issue. And it's just, there are very narrowly drawn national interest criteria. So it's very difficult to be able to get an appointment, even if you fall within some national interest criteria that would allow you to get your visa and be admitted. So another issue is that if you can get your visa, there's nothing precluding you from going to a third country for your 14-day quarantine period. So an individual could be in France, for example, secure their visa, go to Turkey, wait 14 days, be admissible to the United States on the 15th day. So we would really like to see the consulates, start to adjudicate these applications. And the American Immigration Lawyers Association and its litigation partners actually have sued the Department of State to try to get them to compel, processing these applications again. So we'll have to see where that stands. Over at USCIS, we too are still facing really egregious processing delays. So when I hear Charles talk about the time periods for the family-based petitions, what we're seeing is not so bad as that, and not as bad as certain other types of applications. But on average, I think the processing time for many temporary work visa permits or the dependent family members applications runs about on average 9 months. The difficulty is that many individuals, I should step back. USCIS does have a process by which it will premium process or expedite adjudication for a fairly substantial fee. And that is available to certain types of temporary and permanent work visa petitions, but it's not available to dependent family members. And so what we find is we have the principal visa holder who has their status all secured, and then we have the family members who are in status limbo for 9 months, a year, can't renew a driver's license in some areas, in some states. Many of them also are applying for work authorization. They cannot get their work authorization renewed in time, and they have to stop working. So they're losing their jobs. It's impacting the family's economic stability. And it's also another disruption for the workforce, for the businesses that employ these individuals, because individuals simply cannot get the document that they need to be able to continue working, as the case may be. So again, it's the operational challenges, I think, in the near term that we're certainly really focused on and would like to see some improvement in.
Yeah, thank you, Claire. And I'm gonna start it on question and answer. I'm gonna give the panelists at the end a chance to put in some sort of final thoughts on takeaways. And before we get to question and answer, I also want to just flag for people who weren't with us at the beginning, if you can ask questions using the Q&A function in Zoom. Also, if you look under the answered tab in the Q&A box, there is our 2 lists of resources that our panelists provided, as well as some resources from the City Bar Association. If you click the little show all button with the arrow under those, it'll provide you with the links there. I know that one of our questions was, where can I find resources related to business immigration law and changes? I'll let Claire further answer that, but I will just let everybody know that the first couple of the links under resources from AILA, the American Lawyer Association and the American Immigration Council are sort of more general overviews looking at all areas of immigration law, be that family, humanitarian, business. And so those are sort of kind of comprehensive lists of all the changes that have been going on. So that can be a place. But for that question, Claire, do you have any places you would recommend for sort of keeping on top of changes in business immigration law?
I am a big advocate of AILA and the American Immigration Council. There's an excellent resource in the chat or the question and answer area that really kind of highlights what we expect from the Biden administration, what we've seen today, what we haven't seen. Excellent summaries on proposed legislation. Look, our business immigration statute, we basically have had the same thing since 1990 with a few tweaks here and there along the way. So it's a lot of what happens turns on the regulations, but I would really point you to those resources in the Q&A that have some excellent summaries for all of the areas of immigration, including business immigration, or feel free to reach out to me separately, and I will be happy to put some additional resources at your fingertips.
Great, thank you. And so then turning to our next question, it's been asked, is there any indication at all of whether and when prior Attorney General decisions such as matter of AB and matter of LEA may be addressed? And for anyone who's not familiar, those are really groups looking at particular social groups and how those are defined for asylum purposes, related to family claims as well as domestic violence claims, and really potentially affecting all sorts of asylum related claims. But so do we have any indication of how those may be addressed, or if something may be coming down the pipeline? I'll maybe turn that over to if Aaron or Kennji has anything to say on that one first.
Yeah, I would just very briefly say I think they will be overturned. I think it's just a question of when and what it's going to look like, and whether they want to go forward with their regulation first. They've said the executive order that Kennji talked about earlier specifically mentions gender-based and gang-based violence. So we strongly suspect that AB, and they promised to overturn AB on the campaign trail. So it is going to happen, barring some crazy development. It's just a matter of when, and I don't think anyone really knows when that's going to happen. Which is cold comfort for those who have individuals coming up or affirmative interviews.
Does anybody else have anything they wanted to add on that?
I mean, the only thing we know is that the review period is 180 days for those two types of claims. So that would be early August. But that doesn't mean that they would come out with the decisions, then. It could be before, it could be much later, but that's how long the review period was for domestic violence and gang-based claims.
Okay, and then next we have some thank you to Aaron for the good news on the Third Circuit rejection of Castro-Tum. And then related to that, a question saying, are the panelists aware of any other pending or imminent challenges to Castro-Tum in other circuits beyond the 3rd, 4th, and 7th? And again, that has to do with, just for anyone not familiar with the Castro-Tum case, we're talking about the ability of judges basically to manage their dockets with tools like administrative closure.
I'm unfortunately not familiar. It's been settled negatively in the 6th Circuit, so there is a circuit split now. Again, AG Garland can issue a new Castro-Tum at any point rather than hopefully anyone trying to take this one up to the Supreme Court, though Justice Barrett did write the 7th Circuit decision on the issue. So we have one. It actually is, I think, a winning case at the Supreme Court. We just hopefully will never have to get there.
All right, and then let's see. We have someone who says, I hear that the immigration and asylum system described as imposing biometrics upon people who just like us, have better things to do than be arrested and deported? Doesn't this way of doing things come late in history, and mustn't working within the system make a pragmatic settling for a lesser evil inevitable? I think what the question is kind of getting at is our current highly restrictive immigration system. Is this something that's relatively recent and is sort of fiddling with the system as opposed to creating a new system, just perpetuating the problem, is what I think that question's getting at. Does anybody have thoughts on that?
Well, I think in general, U.S. immigration law, at least since 1882, has been pretty restrictive. And if you approach it from the point of view that nobody's coming in here unless they fall within certain specific categories, much less frustrating and demoralizing. But the problems that have existed for at least quite a while is the inability of temporary workers to come here, work in a certain field, go back. So that creates not only more demand, but also build up at the border of people frustrated, particularly trying to get out of certain economic depressed areas in south of the border. So unless we address that issue, until we create a system where lawful immigration can come and fulfill certain important needs, not only business immigration, but also temporary workers in agriculture and other industries, you're going to have a dependence on undocumented workers. And until you have a system that really, I think, encourages employers to use any kind of temporary worker system, you're going to have the same kind of status quo. So it's all complicated, complex morass that has various parts. And unfortunately, I think they all have to fit together to please the various aspects of it, which is why, frankly, comprehensive immigration law is really the answer, as opposed to trying to do it piecemeal, and why, frankly, it's not going to happen. It may happen in somebody else's lifetime, but not from mine. Is that too discouraging? Sorry.
Not at all, not at all. I'll give everyone a chance to end on a positive note in a moment, but I think one more question. It's been asked, who at the Department of Justice or White House is making decisions or not making decisions about issues at EOR, that's the Executive Office for Immigration Review, the agency that runs the immigration courts, as well as decisions about personnel, past Attorney General precedents, creating more judges. Who are the people making those decisions? And I assume that's being asked with sort of the question of what can we do about it? What can be done to sort of influence the people making those decisions?
I confess I'm not entirely sure who specifically at the White House has immigration court in their portfolio. And yeah, I see Kennji shaking his head as well. It's actually a good question because, as I think I mentioned, it's like a huge blank spot in the administration right now is immigration courts. They have Christina Rodriguez from Yale Law, who is an expert on immigration courts, but I'm not sure what her current role is. She was on the transition team. And it really is a little bit of a blank spot. We keep trying to engage on them, and it's not clear who's actually in charge. And I think that's probably why we haven't seen much done in the immigration court system yet.
All right, well, thank you for that. I think unfortunately that is the answer to that question. And I think that gets through, we actually got through most of the questions we had. I do see someone noted that they're not seeing where to find the resources I mentioned before. Again, as I'm seeing it is if you click on questions and answered, and you need to click on the tab that says answered questions. There's a separate tab for that and it's listed there, but we'll also try and make sure that all of these links get circulated out to attendees if they haven't been already. So again, thank you to all of our panelists. This was a fantastic discussion. It's very sobering to hear everything that the realm of immigration has been through in the United States over the past 4 years, and I know it can seem overwhelming. So do the panelists have any closing thoughts or takeaways to leave everybody with tonight? And we can just go through in the order we we went through speaking. Denise, would you mind, not to put you on the spot, but starting us off with some closing thoughts?
I was hoping we'd go in reverse order. So what I would leave with is that what we've heard is a mixed bag. And there's a lot of work. There's been some progress. But man, we are in such a better place than we were before because we have an administration that wants to put in change. And it might not be going as fast as we want or do everything we want. But for the first time in 4 years, immigrants, asylum seekers, refugees don't have a crosshair on their back. And I think that we just have to keep that in the back of our mind because we can only go up from here. And so the mixed bag, it's a mixed bag. We want better, but we're gonna make progress.
Yeah, and I think I have, that's just similar feelings to how I have, what I have right now. Everything is a mixed bag. On immigration, interior enforcement, as I said, like I was worried it was just going to be Obama 2.0, and the enforcement priorities are significantly better than the Obama enforcement priorities, but they're not as good as we wanted them to be, and there's still a lot more to go. So it is a pleasure to have an administration in office that actually listens when we yell at them, and I hope that we will continue yelling at them, and they will continue listening to us over the next 4 years.
Yeah, on the note of yelling, I think the refugee resettlement cap is an example of that, and is a reminder that immigration and asylum, refugee issues remain political, and that for this administration too, political pressure from the public, from members of Congress moves them when they don't believe that there is a base of people who support those policies. So I think that it's a lesson to us that that kind of like people power is still needed to move this White House too.
I'm guardedly optimistic, frankly, that if we have 4 more years of this kind of steady progress, we're going to see a lot of changes, a lot of improvement. At the same time, and maybe I'm showing my age, I've been at this for over 40 years. I've seen a lot of administrative changes. I've seen a lot of hopes dashed. I think simply because we have a Democratic administration doesn't mean we're going to get the kind of decisions we want. People are going to be denied. 99.9% of the officers are still there. It's the priorities that hopefully are going to shift. So it's not everything you want. And frankly, don't spend a lot of time looking at legislation and pending bills because they're not going anywhere. Sorry.
Well, I think there has been progress, there will be progress, and there must be progress. I mean, there was an article April 26th in the New York Times about the US population growth, growing at its slowest rate since the 1930s as a result of declining birth rates and declines in legal immigration. So whatever you think of immigration as a moral imperative, a political imperative, it is going to be an economic imperative in this country as well. And we have an aging population, we have a labor force that's shrinking, and we have a loss of tax revenues in connection with that. Immigration can help us solve the problems we have today and the problems that we're going to have decades from now. So that's my outlook. And I'm sticking by it.
Thank you all very much for being with us this evening. That was a wonderful conversation from everyone. And thank you again to the City Bar for hosting this. And everyone have a wonderful night.